when you go to the doctor or the hospital, it's because something's wrong with you. You go to get better, and if you leave worse off, then you immediately think, well, somebody must have done something wrong. But that's not always the case.
Hey, this is Chaz Roberts. I'm a personal injury lawyer. It's my passion to bring the law to the people, and that's the purpose of this podcast. You are listening to Law Have Mercy. On today's episode, I'm extremely excited because I have a good friend of mine. He's a fellow runner. He went to LSU Law the same time as me, and he does only medical malpractice. Mr. Billy Murray. How you doing, buddy?
Hey, what's up, Chaz? Good. Thanks for having me.
Cool, man. Thanks for coming in today. I hope the drive was okay.
Not too bad. Just, driving through a hurricane. Typical Lafayette weather. Yeah.
I understand it all too well. So you are an associate with Nelson and Hammonds. Is that correct?
That's right. Yeah. I've been there a little over 11, or almost 11 years now.
And you do only medical malpractice?
Yeah, that's all that we do.
You know, it's something we sent a question out to our viewers, like, what do you want to hear about? And overwhelmingly, the response has been medical malpractice. Why does so many people care about medical malpractice?
Well, I think because almost everyone has gone to a hospital or a doctor. And when you go to a hospital or a doctor, you expect to get better. So when you go and you leave worse than when you went, a lot of people think, oh, well, there must have been malpractice. I went to get better and I left worse off than I was before. But that's not always the case. It's very difficult to have a medical malpractice case.
And I've experienced this just in my family and friends. Like when mama or papa pass away, or even, let's not even say someone younger passes away, we have this intrinsic feeling that somebody is at fault or someone is to blame. Would you agree with that?
Yeah, I think so. Like I said, when you go to the doctor or the hospital, it's because something's wrong with you. You go to get better, and if you leave worse off, then you immediately think, well, somebody must have done something wrong. But that's not always the case. For medical malpractice, you have to prove that somebody was negligent that caused the injury. And the law actually says that just because somebody has an injury when they go to the doctor or the hospital doesn't mean that there was malpractice. You have to prove what should have been done and what was not done, and that it caused the injuries.
What are some examples of malpractice?
So some examples of medical malpractice. Something can go wrong during surgery. If the doctor did not do something that they should have done during surgery. For example, if a woman is having a hysterectomy, the doctor should identify the ureter and make sure that he doesn't cut it. If he doesn't identify the ureter and cuts it, that could be considered malpractice. We had a case where a lady had a brain tumor and nobody told her. She had a CT scan of her head, which is, just an imaging study. And nobody told her that it showed she had this giant brain mass. Well, then a year later, she comes back much worse off, and they say, oh, what did they do about that brain mass that you had? And she said, what brain mass? So that's another example. You can have birth injuries.
So let's go back to that
Yeah.
one. Like if someone would have informed her that she had a brain mass, which was identified on the CT scan, the theory I guess you have is that she could have done something about it sooner.
Exactly. Yeah. The CT scan showed a brain mass, and the radiologist who read the CT scan said she needs an MRI so that something can be done. And nobody told her she needed an MRI. Nobody referred her anywhere. So she didn't know. And over the next year, the brain mass continued to grow and caused all kinds of problems to the point that she could barely walk. So she goes back a little over a year later, and it has grown so much that they can't remove all of it. And we had an expert who said if they had told her about it, a year ago, they could have removed the whole mass and she'd be fine. Instead, she had emergency surgery. They couldn't remove the entire mass. And by that point, she had to go to physical therapy and occupational therapy to basically learn to walk again, all over again. She had severe nerve damage. So if they had told her about it earlier and done something about it, she would have had a much better outcome.
A more clear-cut case would be amputating the wrong arm, right?
Yeah, that's another one. I've had a case where a surgeon operated on the wrong leg.
Okay, I was just making one up, but I didn't realize that people actually do this.
No, well, I'll tell you, this surgeon operated on the wrong leg and then refused to settle and said, I didn't do anything wrong. That's the nursing staff's fault. They marked the wrong leg. And, I did surgery on the wrong knee, but that knee needed surgery anyway. So really, I did him a favor. Right. We eventually ended up settling that case, but it blew my mind that a doctor operated on the wrong knee and then refused to settle or refused to admit he did anything wrong. So that's kind of a good example of one of the challenges that we deal with doing medical malpractice work.
Do you ever see doctors actually admit that they made a mistake?
Yes. I took a deposition, which is, where we question a witness involved in the case and a court reporter types everything down and makes a transcript. I took a deposition of a pharmacist who misfilled a prescription, which means, the doctor wrote the prescription and the pharmacist filled it wrong or gave the wrong instructions. In this case, the pharmacist wrote instructions for the patient to drink an entire bottle of liquid all at once instead of taking one.
I shouldn't laugh.
Instead of taking one small dose over like a 14-day period. So he goes home, drinks the entire bottle like the pharmacist told him, and it basically like burned up his insides. His stomach actually looked like hamburger meat is what they wrote in the medical records. So I go to depose the pharmacist. And, one of my first questions after what's your name, what do you do, was, did you breach the standard of care in this case, which is the fancy lawyer term for did you commit medical malpractice? And he said, yes. Well, I had all my questions written out, so I flipped past like 5 pages of questions, and that saved us a lot of time.
Yeah, no further questions.
But,
Have a great day. Have a nice life.
Basically, yeah. So that's one of the rare cases where a pharmacist did admit that they committed malpractice.
So pharmacists fall within medical malpractice as well?
Yeah, really pretty much any healthcare provider, doctors, nurses, hospitals, clinics, pharmacists, chiropractors, dentists, they all fall under the Louisiana Medical Malpractice Act.
I want to get back to that in a second, but I want to ask you, what would be a situation where the doctor would make a mistake? Okay, what is the term you used? Ureter?
Yeah, the ureter is the tube that carries urine from the kidneys to the bladder.
Okay, you know a lot more anatomy than I do. But what would be an example of a situation where the doctor made the patient worse, didn't do something right, but it still is not a viable medical malpractice claim? Or let me just say this, that you cannot collect money from them. Not that you chose not to, but at the end, you just won't win the case.
Yeah, so I'll use something that happened to me as an example. I had hernia surgery last year, and they're supposed to make an incision on the left side of my groin. So before the surgery, the anesthesiologist comes in and says, hey, do you want to have a nerve block, which is an injection that basically numbs you for about 48 hours after surgery.
Very important when you're operating in that area, I would imagine.
Right. And so I said, yeah, absolutely. Please do that. So he did it after they had already put me to sleep. So I didn't know what was going on when he did the injection. As soon as I wake up from surgery, the anesthesiologist says, man, I am so sorry. I did the injection on the wrong side. I injected you on the right side instead of the left side. And yeah, I was still groggy. So I was like, don't worry about it. So was there negligence or malpractice? Yes. He clearly did the injection on the wrong side. Did it cause me any harm? I was probably in more pain than I would have been in otherwise for about 48 hours. But are there enough damages there to make it worth pursuing a medical malpractice case? No.
And how do you define damages?
Damages are basically any injuries, symptoms, conditions that that you suffered that you would not have otherwise suffered without the malpractice.
So the cost to repair you was nothing, right? I mean, he made a mistake. It caused you some pain and some discomfort, but there's no real money to undo what he did, right? Because you were otherwise fine.
Right. And damages can include things like medical bills. Obviously, I didn't have any additional medical bills because of what he did. Physical pain and suffering, mental anguish and distress.
Time away from work.
I didn't have any of that. I was off work for a week anyway. So I really didn't have any damages. I guess you could say I had 48 hours of more pain and suffering than I would have had otherwise, but man, I would have been in pain and been suffering anyway. So yeah, not worth pursuing a medical malpractice case because they're very expensive and very time consuming. So those are all factors we have to take into account when we weigh whether it's worth it to file a claim.
What do you think the average cost is it to your firm to bring a medical malpractice case to certain junctures? Can you, I mean, I know it's hard, every case is different, but we're talking thousands of dollars minimum, right?
Yeah, so on the front end, just to file the claim, it's $100 per defendant. So if you've got a lot of defendants, for the average person, that can add up pretty fast. Then to get the medical records, that can be a couple $1,000s depending on how many there are, especially if they're in the hospital a long time. I mean, that can get up to like $5,000 just to get the records.
Just to get the records.
Yeah, yeah. Then if you hire an expert, that could be another $10,000. And if you end up going all the way to trial, that could be, $50,000 to $60,000 to try the case.
Billy, you mentioned multiple defendants. Why would you have multiple defendants in a single case? I mean, you talked about a doctor. Why would you have different parties?
Yeah, so you could have, if it's a surgical case, if something went wrong during surgery, sometimes there are multiple surgeons. Sometimes if there's a missed diagnosis where a doctor should have caught something, sometimes there are multiple doctors who failed to catch it. Really, one thing that's important in medical malpractice cases is to name anyone who could have done something wrong, because you don't want to have an empty chair there where one doctor is able to point the finger at another doctor and say, well, yeah, I missed it, but so did he. Well, if you didn't name that doctor that they're pointing at, then you're in trouble. And that's one reason that you should call us if you think you might have a medical malpractice case.
Do you think, are there situations where something goes wrong in a surgery, but the doctor says, well, you consented to that potential risk? Can you explain consent?
Yeah, absolutely. And that's something that happens all the time. For like the example I used earlier, if a woman goes in to have a hysterectomy, which is when a doctor goes in and removes the uterus and the ovaries. Well, before you have any surgery, they're going to ask you to sign an informed consent form. And usually, it's one of those papers, they throw a whole bunch of papers at you right before you go in for surgery.
Yeah, I'm signing.
Yeah, and they're like, sign here, sign here, sign here. Don't tell you it's important or that you need to read it. One of the forms you're signing is an informed consent form. And one of the things that it lists are some bad things that can happen during the surgery that you consent to. And it'll have, for example, for the hysterectomy on that list, it'll say, damage to the bladder and the surrounding organs. Well, the ureters are one of the surrounding organs. So in that situation, the doctor is going to say, well, the informed consent form lists damage to surrounding organs. Yeah, I cut your ureter, but that's something that you consented to, that you said could happen. And they try to use that as saying, well, you consented to this and it happened, but you can't consent to medical malpractice. That's our argument against that. And just because it's on that list of things that can happen doesn't mean that it was not caused by malpractice. But that's another challenge we face, is we have to prove what the doctor should have done, which that's the standard of care. Standard of care is kind of the lawyer phrase for what should the doctor have done. Breach of the standard of care is what did the doctor do or not do that they should have done or shouldn't have done. So we have to prove not only did they cut the ureter, what they did negligently that caused them to cut the ureter.
Now, correct me if I'm wrong. During COVID, that standard of care has been made even more or less difficult to meet, right?
Yeah, so that's kind of a hot issue right now. We're waiting on the Louisiana Supreme Court to weigh in and issue an opinion about what this statute means. But in March of 2022, Governor Edwards declared a state of public health emergency because of COVID.
Was it 2020?
Or 2020, yeah. March.
This is peak COVID, or I guess the beginning of the COVID craziness.
Yeah, so it was March of 2020, he declared a public health emergency. And that triggered this statute that says healthcare providers have immunity during a state of public health emergency declared by the governor, except for gross negligence. And I don't want to get down in the weeds too much, but this statute is so broad, it doesn't say immunity from medical malpractice. It just says immunity. So theoretically, if you take this statute, then a doctor who rear-ends someone during a public health emergency has immunity unless he was grossly negligent. That's how broad and messed up this statute is.
He's got to rush to the hospital, man.
Yeah,
he's got to rush to the hospital to take care of COVID patients,
exactly.
Right?
So they kept renewing the public health emergency until March of 2022. So if the malpractice happened between March of 2020 and March of 2022, it may be harder to win that medical malpractice case.
So you have 2 years of operations. Now, whatever the intent of the statute was, I'm assuming that the purpose of the statute is, look, hospitals are inundated with patients. Healthcare workers are severely overworked. We have a crisis on our hands, so we're going to lax the responsibility on the doctors a little bit. But it applies to every single surgery. It could apply to a breast surgery, a plastic surgery not related to anything COVID, but that statute is in place protecting those doctors for that 2-year period. Am I understanding that?
Yeah, that's a great point. There's no requirement in this statute that they prove that the surgery or procedure or whatever it is had anything to do with the public health emergency. So if a woman goes in for a breast reconstruction surgery and the doctor messes up, well, that had nothing to do with COVID, but under this statute, it doesn't matter.
It could be in a boutique hospital setting somewhere. It could be in a doctor's office, right? I mean, you can have malpractice in a doctor's office. It could be a plastic surgeon's office.
Yeah.
There's no correlation with COVID whatsoever, but you're having to take on that fight.
Right. And the statute was created during Hurricane Katrina because they wanted to get doctors from out of the state to come help during Katrina without having to worry about getting sued for malpractice when they come help out. So that's why the statute was created. And now, in my opinion, it's kind of getting twisted to try to protect doctors and give them a level of protection even greater than they already have.
So those fights, or that fight, is taking place now and next year and the year after based on procedures that probably took place between 2020 and 2022, right?
Yeah, that's right.
We're not going to know where the cookie crumbles until it gets through litigation.
Right. I mean, we're talking about surgeries that happened in March of 2020 that just now some appellate courts are issuing opinions about what does this statute mean. And ultimately, it's going to come down to what the Louisiana Supreme Court says. So we're still waiting to see what they say, to see what this actually means, for victims of medical malpractice.
But it's certainly in that period of time, procedures that are taking place in that period of time, you have to give them a long, hard look and see if this is a viable claim because of the law.
Yeah, we've got to be a lot pickier. We've told a lot of people, unfortunately, hey, normally we would take this case, but here's what this statute says. And because your case falls within this 2-year period, we don't think we can prove that what the doctor or the nurse or hospital did rises to the level of gross negligence. And that's another problem with it. What does gross negligence mean? I don't know. Courts haven't really helped out much.
It means a big mess up, a big boo boo,
Yeah,
a bigger boo boo than before, right?
basically, yeah. They said it means the entire absence of care. And I've seen some doctors say, well, yeah, we think that there was negligence in this case, but they were trying, so there wasn't gross negligence.
I'm not a medical malpractice lawyer. I have received dozens, if not hundreds, of calls from medical malpractice over the course of my career. I've consulted with you on many of them. What percentage of cases that you get calls on do you actually take?
So we get about 100 calls about medical malpractice every month. I would say we turn down probably 90% or so, just, on the phone or on the front end. And of those 10% that make it beyond that initial call, we'll get the medical records and we'll take a look at everything. And in about 5% of those, we say, based on the medical records, we don't think this is a winnable case. So we end up taking about 5% of the calls that we get because it's so hard to have a winnable medical malpractice case in Louisiana.
And your experience as a medical malpractice lawyer, and because that's all you do and that's what your firm was built on, your firm is literally the most experienced in Louisiana. Is that right? I mean, in terms of being there from the beginning.
I think that's fair to say. I'm at Nelson and Hammonds, and John Hammonds was one of the first attorneys in Louisiana to start doing a lot of medical malpractice work in the late 70s. So he's been doing this for over 40 years now. So I've learned from the best.
Well, that experience really helps you on screening because you're saving a lot of people a lot of time, money, and distress trying to pursue what they think is a viable claim, right? You're doing clients a favor in a way. I've noticed that in my practice. When you have that honest conversation and say, I love you, I wish I'm so sorry what happened to you, but you just don't have a viable claim. That's a service that you're providing people, even if you don't take the case. Would you agree with that?
Absolutely. One of the other attorneys in our firm, Cornell Flournoy, she's been with John since 1986. And she likes to say that sometimes the best way we can help someone is by telling them no. Because if you tell them yes or maybe, you give them false hope. For medical malpractice cases, if you end up trying the case, it can take 4 to 5 years. So
That's a tough battle.
Yeah, it is.
For the client, for the lawyer for sure, but for the client too. You're calling them for more information. You're asking them to give a deposition. They're reliving the event in their mind over and over. They get fixated on it potentially. I'm not saying everyone, but some people. And so by giving them that closure and saying, I am sorry that this happened to you, however, this is not malpractice, or you don't have a viable case, not even saying it's malpractice, you don't have a viable case, they're able to close that chapter in their book and move on with their life.
Exactly. And we also feel like we're kind of doing a service to the medical community as well. Believe it or not, I know that doctors and nurses are human beings, and that if we file a claim against them, it's going to take a toll on them mentally, and it can impact their lives. So we don't want to file frivolous cases or claims that we don't think are winnable, because we know that it takes a toll on them as well. So we're very, very careful in what cases we take on.
And when you sign your name to a petition that you do believe that this is a good case, I know in my own experience, the defense lawyer says this must be a good case because Chaz or Billy don't file bad cases, right?
Yeah, and I think that that is one thing that our firm has a reputation for, is when a defense attorney gets a case and they see, okay, this is filed by Nelson and Hammonds, there is something to this case. This is not a frivolous case, because they don't pursue frivolous cases. I think that's a reputation that John Hammonds has built over the past 40 years. And it's a reputation that I take seriously and that I want to carry on.
Billy, I'm going to give you a tough assignment. All right. You talked about the 90% cases you screen right away. You talked about the next group of cases that you do some more due diligence and ultimately may decline the case. And then you talked about the 5% where you actually do. Maybe it was less than 5% where you actually take the case. Can you give me an example of each? Of one of a person who would just call, let's go to the 90% first, that you just right away don't take the case.
Yeah, so there are a lot of reasons that we turn down cases on the front end, and the reasons kind of go back to all the traps that are in the Louisiana Medical Malpractice Act. For example, you've got deadlines for filing the claim. You got to file within 1 year of the date of malpractice or 1 year of the date of discovery of malpractice. But no matter when you discover it, you've got to file it within 3 years. So sometimes I get calls about surgeries that happened in 2016. And even if they say, well, I didn't really know that it was causing me problems until last week. Well, it was more than 3 years ago. So unfortunately, under the law that we're stuck with, it's too late to file that claim. So that's one of many reasons we might turn down, that 90% of.
So let me get this straight. You have 1 year to file a malpractice claim. You have 1 year from the date of discovery if it's not automatic. If you cut off my wrong foot, my 1 year probably starts from there. But if it's something that is not yet discovered that I have the issue with, it's 1 year from the discovery. But in every case, regardless if they cut off the wrong foot, whatever happens, 3 years from the date of the procedure or the act, you don't have a case.
Right. Unless the doctor committed fraud or did something to hide it, actively hide it from you, maybe falsifying medical records or something like that. No matter what, it's 3 years from the date of malpractice.
But that would still be a dogfight to prove fraud or anything else, right?
Oh, absolutely, yeah.
Okay, now give me an example of the ones that you have a conversation and you do some more due diligence.
Yeah, so, if we get a call and based on what the client tells us, yeah, it sounds like it might be a good medical malpractice case. We'll sign it up, order the medical records, get those. I review all the medical records in my cases on the front end, just so I have a good feel for the case. I kind of know what to look for by this point. Sometimes I see stuff in the medical records that either the client misunderstood or that they didn't tell me about. So sometimes I see things in the medical records that make us rethink, okay, this is not a winnable case based on this or based on that. And sometimes it goes back to prescription. Prescription is the deadline that you have to file a claim. So sometimes we'll see something in the medical records that shows, well, it can be as simple as the client thought the surgery was in February of 2022. Well, no, it was in December of 2021, which was more than a year ago. So now the claim is prescribed or the deadline has passed for filing the claim. So there's all kinds of stuff we can see in the medical records that'll make us change our minds and think, this isn't a winnable case after all.
Yeah, I know from my experience sending a couple cases for you to review. You'll ask me for the medical records. I'll send the medical records. You'll go through them with a fine-tooth comb. I don't know where you find all the time to do this, man, but I'm seriously impressed with the way you go through these medical records. But you'll find something and say, hey, Chaz, this is a problem here, 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 and here. That's why this is not a good case. And that's an example of your due diligence once you actually look at the medical records, right? Because the client doesn't know what's in the medical records most of the time.
Right, that's right. Usually the client has never seen the medical records. So yeah, that's something we can't find out until we get the medical records and review them ourselves.
And then the last percentage is one where everything lines up. Can you tell me what elements have to line up to actually take the case?
Yeah, it's almost like the stars have to align perfectly to have a winnable medical malpractice case, and that's why we have to turn down so many. First, we have to make sure the deadline hasn't passed, and as long as the deadline for filing the claim hasn't passed, then we go back to those 3 elements that we have to prove to win the case. We have to prove that there was malpractice, that the malpractice caused damages, and that those damages are worth enough to make it financially worth pursuing the case, to cover the cost of pursuing the case and still be able to pay the client anything, from a settlement or judgment.
That makes sense. Louisiana has, not only is the law very difficult, but there's an actual cap on what you can recover, meaning there is a limit of what you can recover from doctors. Is that fair?
Yeah, that's right.
Okay. And what is that cap?
So in Louisiana, the cap for medical malpractice cases is $500,000 in what's called general damages. General damages include things like physical pain and suffering, mental anguish and distress, lost earnings, lost earning capacity. Basically, the only thing that's not included in that $500,000 cap are any medical bills that were caused by the malpractice and any future medical treatment that might be required because of the malpractice.
Do other states have caps like in Louisiana?
They do. There are currently 29 states that have some sort of cap on medical malpractice.
I would imagine the states that don't have a cap, those are probably some very big cases, right? I mean, I'm sure there are lawyers that handle. I'm sure there are a lot more lawyers in non-cap states that handle medical malpractice. That's just my guess. I don't know.
Yeah, I think in Louisiana there aren't a whole lot of lawyers who do exclusively medical malpractice work. But in states like Arkansas, for example, where not only do they not have a cap on medical malpractice cases, they have a provision in their constitution that says you can't have any caps on any cases. So there are more lawyers in Arkansas that do medical malpractice work.
Billy, you're damn near in Shreveport. I mean, in Arkansas at Shreveport, right? I mean, how can you be that close to another geographical location, and the thought process is so different on medical malpractice?
Yeah, it is kind of crazy. That $500,000 cap was created in 1975, and it has never gone up. In 48 years, it's still the same.
So that's not inflation adjusted. I mean, that's 500,000 today versus 1975.
Yep.
I don't know what it is. Probably like closer to 2 million, right? I mean, it's got to be up there.
Yeah, something like that.
So what's the purpose of actually having a cap?
So back when the cap was created in 1975, there was what's been called a medical malpractice insurance crisis. That's what they call it. More medical malpractice claims started to get filed, and doctors, hospitals, and their insurance companies panicked and asked politicians, hey, can you do something about this? And they did something about it, and that was to create the Louisiana Medical Malpractice Act of 1975 that created that $500,000 cap on damages. There have been some constitutional challenges to the cap, where plaintiffs have said, hey, this is unconstitutional. How can you legally limit my damages when, if I got rear-ended in a car wreck and broke my neck, I could get $20 million, just hypothetically. But if I have that same injury from medical malpractice, I can only get $500,000. How is that fair? Well, in 1992, the Louisiana Supreme Court said, well, we know that it doesn't completely compensate you for your damages, but you do get other benefits, like that the doctors are going to have health insurance or malpractice insurance. It's easier to get paid. So it creates a balance, and that's fair enough. So it's not unconstitutional. Then in 2012, they had another Louisiana Supreme Court case.
Let me back up.
Yeah.
What the Supreme Court is saying is that society overall benefits by having the cap and that balance, because we will have some form of compensation to people that are injured, and the insurance rates are not going to be so high that more doctors will have insurance, and by not having uninsured doctors, everyone's going to have insurance, and we can at least cover most injuries, even though it's not going to be the top line windfall. Is that fair?
Yeah, that's exactly right. And I think their exact language was, it creates a fair balance between the rights of victims of malpractice and the healthcare providers. And they're not entirely wrong in that, if you have a car wreck, you might get a $30 million judgment, but you've got to worry about how much insurance coverage does the defendant driver have? And that's kind of your limit. So in our case, we know what the doctor's malpractice, or insurance limits are, and we don't have problems, recovering money if we get a judgment. So there are some benefits to the cap.
And so what I would say is, let's look at the insurance companies and see how solvent they are, right? Are they making huge profits? Are they breaking even by all these medical malpractice claims? What's going on with that? So have you done any of that research?
I have. And first of all, one thing that some people seem to worry about when it comes to medical malpractice cases is, well, with all these lawyers filing medical malpractice claims, is my health insurance going to go up? I've seen no correlation whatsoever between people's health insurance rates and medical malpractice claims. Now, as far as the malpractice insurance rates for doctors, hospitals, nurses, the biggest insurance company for medical malpractice is 𝐒𝐥𝐸𝐞. And in 𝐒𝐥𝐸𝐞's 2021 annual report, their 2022 hasn't been released yet, but in their 2021 annual report, they reported that they have assets of $495 million. They reported $11 million in net income. And not only that, this malpractice insurance company has so much money that they gave back a 3.5% dividend to the doctors, nurses, and hospitals who are insured by them. So they not only are they running out of money, they have so much money they're giving it back to their insureds, and they reported that malpractice rates had not gone up at all from 2020 to 2021.
So are you suggesting that, once again, like I always talk about on this podcast, we shouldn't feel sorry for insurance companies?
No, not at all. And there's another organization called the Patients Compensation Fund that kind of acts as an excess insurance company for private insureds. So they pay everything over $100,000 in damages, and they've also got plenty of money.
Why should people support the work of medical malpractice lawyers? Why is medical malpractice so important to the public?
Well, I think it goes back to the theory that everyone should be held accountable for their actions if they hurt someone else. If I run a red light and rear end someone, I'm probably going to get sued. I'm going to be held accountable for my actions. And I think that healthcare providers should be no different. If a doctor, a nurse, or any other kind of healthcare provider does something that hurts someone, they should be held accountable for their actions. And I like to think that it helps the quality of healthcare. If healthcare providers know that they could be held accountable for their actions, hopefully they'll be more careful. If they get sued for malpractice, hopefully they won't make the same mistake again. So I like to think that in a way we are helping the quality of healthcare in Louisiana by pursuing good medical malpractice cases.
It's a way of checks and balances, right?
Exactly. Yeah.
So without any oversight with civil penalties, right? Because the state governments can only supervise doctors through the license issue, through a license, but without having some type of civil repercussions, they would not take this. Some would not take the same precautions and precision and due diligence in their actions.
Exactly. Yeah.
And I'm sure many of the things that we take for granted in our hospital stay have probably come into play through civil repercussions, right? At some point.
Yeah, I mean, there have been situations where hospitals have actually changed their policies because of medical malpractice cases. And you're right, a lot of those hospital provisions are because, something happened in the past. Like a lot of the time when people see a warning on something, they think, oh, well, that must be because of lawyers or something must have happened. Well, yeah, except with hospitals and those are policies that can save lives. So that is one benefit of medical malpractice cases in Louisiana.
You mentioned hospitals. Does medical malpractice also apply to nursing homes?
Yes, hospitals, nursing homes, rehab facilities, basically anywhere that healthcare is provided um, falls under the umbrella of medical malpractice.
I get quite a few calls about nursing home situations. Do they have a lot of issues? Is it a staffing or manpower issue, or is it just dealing with frail individuals on a daily? Is it just a harder environment to work in? What do you think?
Yeah, I think it's all those things. We get a lot of calls about nursing home negligence cases. Understaffing is an issue. And you're right, you are dealing with what can be difficult patients. They're older, they're more frail. A lot of them have mental disabilities, dementia, Alzheimer's, things like that. For example, we had one case where it was a lady in her 80s who had dementia, and she was what's known as a wandering risk. They knew that if they didn't keep an eye on her, she would wander around the nursing home, and there was a chance that she could wander off. So, this nursing home had a courtyard that the residents were allowed to go outside and, sit outside and hang out in the courtyard. There's a gate in the courtyard that an employee had left unlocked. So this lady wandered outside on a hot summer day, and the gate was left unlocked. So she went out the gate, and they found her about an hour and a half later, passed out, slumped up against a brick wall. Her temperature was 106 degrees,
Wow.
and she had second-degree burns all over her body. So they rushed her to the hospital. They had to do a lot of debridement procedures, which is where they basically take a knife and scrape your wound to scrape off all the dead tissue. Extremely painful, and she had that all over her body. So that's one example of a nursing home case that we've had.
How can you just describe how it meets those elements that we talked about earlier?
Yeah, so was there negligence? Yes, they knew she was a wandering risk. They knew she had dementia. They knew they needed to keep an eye on her. They also knew that they shouldn't leave the gate open, so that patients that are wander risks could wander outside. So was there negligence? Yes. Did their negligence cause any damages? Yes. Because of their negligence, she was able to wander outside, wander out the gate. Did it cause any damages? Yes. She had second-degree burns all over her body, had to stay in the hospital, racked up a bunch of medical bills. So that's a case where you had all three elements. You had negligence, causation, and damages. And the damages in that case were worth enough to make it worth pursuing a case.
Are slip and falls, when patients slip and fall in the hallway at a hospital, is that considered medical malpractice?
That's a good question. It can be. Okay, so that's a good question because I've seen cases where if it's a patient in the hospital and they slip and fall, because they are there to receive health care, it does fall under the Medical Malpractice Act. If it's somebody who is there visiting a patient in the hospital, they slip and fall in the hallway, it's not a medical malpractice case because they are not a patient and are not there to receive health care. And that may be different from, Louisiana has different appellate circuits. That may be different from, I'll say, one part of the state to another. The law may be a little different. But yeah, that's a good question.
What about bed sores? Someone's in a nursing home and I'm asking these questions because these are actual phone calls that I've received over time. Bed sores, right, or some type of mistreatment that's not to the extent of your example. Would that be considered medical malpractice?
Yeah, we get a lot of calls about bed sore cases. And people like to send me pictures of bed sores because
Don't you love that?
Yeah. Yeah, I see a lot of things. But they think,
Yeah, how many breast implant botched surgery pictures have you received? I've received a few.
So many. Yeah. But they think, well, look at these pictures. How can this not be malpractice? These bed sores are so bad. I can literally see the bones through these bed sores. How can that not be malpractice? And just because something looks really bad doesn't automatically mean that it was caused by malpractice.
Are we talking about breast implants or bed sores here?
Both.
Okay.
Yeah. But like with bed sore cases, those are very difficult to win because bed sores can just happen even without malpractice. If a patient has diabetes, they're more susceptible to bed sores. If they've had surgery and have trouble moving on their own, they're more susceptible. But there are things that should be done to prevent bed sores, like ordering pressure mattresses that kind of shift to so that the patient isn't putting pressure on one area for a long period of time. They have turning schedules. The patient should be turned every 2 hours. And if they didn't document that they did those things that they were supposed to do, and the patient ends up with bed sores, then that could be a good case.
But Billy, we still have to meet the third element of damages, right? So maybe you have bed sores, maybe there was negligence, but how much could a bed sore case possibly be worth? I'm just throwing that out there. I don't know, right? I mean, I would imagine, it'd be difficult to spend $5,000 to $10,000 on an expert in bed sores for your top end recovery of basically a flesh wound, right?
Yeah, and it really depends on the extent of the bed sore, what kind of treatment is required to fix the bed sore. If it's something that gets infected and requires months of treatment, multiple, like I said earlier, debridements where they have to take a knife and scrape away all the dead tissue. Bed sore cases can be worth it. But if you've got some ankle blisters that they recognize almost as soon as they develop and they treat them, those probably aren't going to be worth pursuing. There probably aren't enough damages there to make it worth it.
Billy, what happens if I'm in an ambulance headed to the emergency room and there's a wreck caused by the ambulance. Is that considered medical malpractice?
That's another very good question.
Why not? I'm gonna throw. You can say I don't know. I say I don't know all the time.
Uh, I would be happy to do some more research on the issue and get back to you.
Well, let me ask you this: is a paramedic considered a medical provider under the med mal law?
Yes.
Okay.
Yeah. Paramedics, fire department, if they're providing medical treatment, we've had cases where the fire department comes to someone's house, they think they're having a heart attack. The fire department or EMTs who come to the scene say, we think you're fine, you don't need to go to the hospital, and then they die a few hours later. That would be a medical malpractice case. And we've had cases like that before, where if they had taken them to the hospital when they had complaints of chest pain, they could have done something about it to prevent them from dying.
And there's going to be an expert on the other side that says, no, he was a goner anyway, right?
Usually, yeah. The defendants will hire an expert who says, yeah, he probably would have died anyway, even if they had taken him to the hospital.
Yeah. You would have, they could potentially make two defenses at least, and then say, well, based on the vitals, it was within the standard of care to not take him to the hospital at that particular second. Or the other defense might be, yeah, but he would have died anyway.
Yeah. And that's something that experts do a lot in medical malpractice cases is they'll, cherry pick certain facts from the medical records and ignore other facts that go against their theory. But yeah, that's definitely an argument that they could make.
Another reason why I don't handle medical malpractice claims and why I believe that anyone should hire a medical malpractice specialist would be when I represent someone in a car wreck, I know what to do. All right, I open an insurance claim. If within a year I haven't settled it, I go to the courthouse, I file a petition for damages, it starts the process every single time. Medical malpractice has a different playbook, and it's very specialized and it's very specific. It's called a medical review panel, right? You have to go through a medical review panel before filing a lawsuit.
Yes.
And you have 1 year to do that from the injury or discovery of the injury.
Yeah, to file the claim, which starts the medical review panel process.
File the claim, can you talk briefly, and I don't want to put everyone to sleep, can we talk briefly about the medical review panel and just how that's different than your normal tort claim like a car wreck?
Yeah, so normally, like you said, if you have a car wreck, you can file a lawsuit in court right away. Don't have to do anything, go through any process first. For medical malpractice cases in Louisiana, before you can file a lawsuit in court, you have to go through what's called the medical review panel process. And the way that works is you file the claim, and then they notify the defendants, hey, you've had a medical malpractice claim filed against you. And then they get an attorney, and their attorney calls me and says, hey, I'm representing this defendant in a medical malpractice case. So the first thing that we do as part of the medical review panel process is pick what's called the attorney chair. And that's just a lawyer who kind of organizes the medical review panel. So we usually agree on an attorney chair, and they get appointed. And then the attorney chair comes and says, hey, Billy and defense lawyer, I've been appointed as attorney chair. Billy, appoint a doctor to the medical review panel.
So you pick a doctor.
So we pick a doctor to put on the medical review panel. There are 3 doctors. So we pick one, and then the defendants pick one, and then those 2 doctors pick the 3rd doctor.
Wow.
So then the panel's complete.
These are all Louisiana doctors?
Yeah, they have to be doctors licensed to practice in Louisiana. And if the defendant is a specialist, like let's say they're an orthopedic surgeon, then the doctors on the medical review panel have to be orthopedic surgeons.
Interesting. So the medical review panel is comprised of an attorney chair, not you, an attorney chair, 3 doctors, one that you pick, one the defendant picks, and one that is picked between the plaintiff doctor and the defense doctor. They pick the third doctor.
Right.
Okay. Then you submit your medical records and your argument of why this was malpractice. The defense lawyer submits a brief opposing why it's not, stating why it's not medical malpractice, and a decision is rendered from those three doctors.
That's right.
I got it right so far?
That's right.
Watch out, I might start doing that now. No,
very
you can have it, brother.
Yeah.
I can't take the pictures. All right. So then what happens once that decision is made, good, bad, or otherwise?
Yeah, so they issue a written opinion about whether they think there was malpractice. If there was any malpractice, did it cause any damages? And if so, what damages? So you've got this written opinion that's basically treated like an expert report. It doesn't decide the case. Even if you lose 3-0, all three doctors say there's no malpractice, you can still file a lawsuit in court. You've generally got 90 days from the date that the panel opinion is issued to file the lawsuit in court. Now,
and this is just the same court that I filed my car wreck case.
Exactly.
Okay.
Yeah, and the medical review panel process alone can take 1 to 2 years, sometimes more. Yeah.
Ouch.
Yeah, that's another reason a lot of lawyers don't want to bother with medical malpractice cases, is they take so long, and it takes so long to get paid. When we file a med mal claim, we do it knowing we may not get any money out of it for 4 or 5 years.
Just to get an opinion from a panel to see whether there is any merit in the case before you even start the lawsuit process takes 1 to 2 years.
Yep, or sometimes longer.
I'm sure during COVID, it probably didn't help things.
No,
right?
Not at all. Yeah. The biggest problem since COVID is it's taking a lot longer to get medical records.
Absolutely.
Yeah.
I have that struggle as well.
Mm-hmm.
I'm dealing with emergency room records every day, and it's just long.
Yeah, it seems like what used to take, maybe a few weeks, 1 month, now can take 3 or 4 months, sometimes 6 months, which that's another reason it's important to call an attorney as soon as possible if you think something is wrong.
To get the ball rolling on the medical records.
Exactly.
So you get the medical you get the medical opinion for the medical panel, you file a lawsuit. So then it just becomes your standard case with deadlines, but that's going to take another 2 to 3 years to get it to trial, right?
Exactly. Yeah. It's taking a long time to get trial dates right now. And that's another thing that has gotten worse after COVID is, we're scheduling trials for like summer and fall of 2024, and we're in March of 2023.
Oh, man, it's terrible.
And they tell us, this is the first available date that we have.
Right.
So it takes so long to get a trial date.
But Billy, you can settle after the medical review panel. You can settle the case. Do you ever do that?
Yeah, technically you can settle at any point in the process. I've had cases where I filed a claim and I get a call from the defense attorney, first call I get saying, hey, my client wants to settle this. That's pretty rare, but it does happen. A lot of the time, if we win the medical review panel 3-0, which is not easy to do, if we win the medical review panel 3-0, a lot of the time the defendants will say, okay, 3 doctors were willing to say, I committed malpractice, I better settle this. Not always. Sometimes they're hard-headed or stubborn, or just think the panel is wrong, to be fair. But yeah, sometimes it can settle after the medical review panel.
Billy, if I think I have a medical malpractice claim for myself or a family member, what steps do I need to take?
The first thing you should do is call us as soon as possible. Like you said, to get the ball rolling, because it can take weeks or months to get the medical records, and that's something we need to do to evaluate the case and help us file the claim if we end up filing a claim. Another thing to do that I encourage is to write down your story. Do it when it's fresh in your mind. You don't have to do it all at once. You can write down what you're thinking, come back to it later, add more to it. Because a lot of the time when people call attorneys, they're emotional, they're stressed out, they're upset, and they may forget to tell us something important about the potential case. Well, if they've got it written out, if you want to read it to me over the phone, that's great. If you want to email it to me to look at, that's even better. But just putting it in writing will make sure that you don't leave out any important details when you do talk to the attorney. Also, if you could get the medical records yourself, that would help us a lot. Nothing makes me happier than when I talk to a potential client who it sounds like they have a good case or might have a good case, and then they say, "Oh, I've got my medical records. I can email them to you or drop them off to you at the office." I say, "That's great. I can look at them today." If they hadn't done that, it could be months before I'm able to, look at those medical records. So get your medical records, put your story in writing. Do not wait to call us, and do not threaten to sue anyone. Don't tell your doctor, you're going to make them pay or I'm going to call a lawyer, because I've had so many cases that sounded good, and then I get the medical records and there's stuff in there saying this patient threatened to sue us, said they were going to make us pay. And if it's a borderline case and I see something like that, that can make me want to turn the case down, because what they'll do, the defense attorney, if it ends up going to trial, they will use that to the jury or the judge and make you look like a money-hungry person who's just in it for the money. It's going to make them not like you, make it look like you're just in it for the money. At the same time, don't negotiate with their insurance company or their hospital administration. If they are offering you money or want to sit down to discuss the case or potential case, if you're at that point, you should call an attorney.
People have the right to their medical records, right?
Yes, it is easier for patients to get their medical records usually than it is for us to get them. Now, and this is another important thing they can do, if it's a family member who is the patient or a family member who died, if they died, you're going to have the death certificate to get the medical records.
Well, Billy, I learned a ton today, and thank you so much for being our guest. I know this information is going to be super helpful to people. Where can people find you?
Yeah, so we have offices in Shreveport and Lafayette. You can call us at 318-227-2401, and that's the number for the Shreveport office, but we can patch you through to Lafayette. Or you can go to our website. It's www.nelsonhammonds.com.
Awesome, man. Thanks a lot.
All right.
Hey, it would mean the world to me if you subscribe to the podcast and leave us a 5-star review. It helps keep the show free, and it helps us book better guests to provide more valuable content to you. None of the opinions expressed by my guests are that of my own, and nothing we talked about creates an attorney-client relationship or could be construed as legal advice. Hope you enjoy the show.